Good morning. My name is Charene Nortier and I'm from the Conduct of Business Supervision Division at the Financial Sector Conduct Authority. With me today is Nare Senyatsi, who is from the Licensing Division. Good morning, Nare, and thank you so much for joining us.
Thank you, Charene.
Nare is a specialist in talking about debarments and reappointments, specifically the Section 14(1) debarments. Nare, this is a topic that a lot of people are very interested in, and it's very useful for businesses and representatives to understand exactly how this works. So without any further ado, I'm going to ask you to take us through this very important topic.
Thank you, Charene. Thank you, everyone. I hope everyone is well and safe. Thank you for joining me for today's webinar. My name is Nare Senyatsi, a licensing support manager at the Financial Sector Conduct Authority. I have joined the FSCA in 2016, and today I'll be presenting Section 14(1) debarment and reappointment of debarred representatives. So, Section 14(1) debarment is a regulatory instrument intended to rid the industry of incompetent and dishonest representatives. So the industry is pretty much self-regulating when it comes to appointment, debarment, and reappointing of the representatives to ensure that only competent and honest representatives are rendering the financial services. A financial services provider must have procedures in place to ensure that it can debar any representatives that no longer complies with the fit and proper requirements or has contravened or failed to comply with any provisions of the FAIS Act in a material way. When a representative is debarred in terms of the FAIS Act, such person is prohibited from rendering financial services, and the FSP must withdraw authority granted to that representative to act on its behalf. The obligation on the FSP to debar an authorized FSP must debar a person from rendering a financial services who is or was a representative of the FSP if the financial services provider is satisfied on the basis of available facts and information that the person does not meet or no longer complies with the fit and proper requirements or has contravened or fail to comply with any provisions of the FAIS Act in a material manner. Just to go back to my earlier statement, only authorized FSP can debar. If the FSP is not authorized, it cannot debar any representatives. So an FSP can debar a representative who is or who was a representative, meaning that even if the rep has resigned from the provider, the FSP can still debar such a person. We have seen in the past whereby the reps are anticipating that they will be debarred and they resign, moving away from the debarment. However, the FSP still retain the obligation to debar such a person. Right, before effecting a debarment, the FSP must ensure that the debarment process is lawful, reasonable, and procedurally fair. For example, an FSP cannot utilize Section 14(1) debarment to settle contractual dispute between the provider and the representatives, because that will render the debarment unlawful. For a debarment to be procedurally fair, there are certain processes that must be followed before debarment and after debarment. So now I will take you through the process that must be followed before debarment, and later on we'll look at the process that must be followed after debarment. An FSP must, before debarring a person, give adequate notice in writing to the person stating its intention to debar the person, the grounds, and the reason for the debarment. The FSP must provide the person with a copy of the FSP's written policy and procedures governing the debarment process, and give the person a reasonable opportunity to make a submission and response. And the FSP must consider any response provided before taking a decision. And once the decision has been taken, the FSP must immediately notify the person in writing of the FSP's decision. When we mean immediately, immediately means immediately, not after 2 days, not after 3 weeks. Immediately, the FSP must inform the person in writing of the decisions. Following are the process that must be followed after the debarment has been effected. The FSP must immediately, and immediately we mean immediately, withdraw any authority for the person to act on behalf of the FSP. The FSP must remove the name of the debarred person from the representative register, what we normally call a rep register. Immediately take steps to ensure that the debarment does not prejudice the interest of the client of the debarred person. The FSP must notify the authority within 5 working days of the debarment and provide the authority with the grounds and reason for the debarment within 15 days. These are the steps that must be followed before debarment and after debarment for debarment to be procedurally fair, right? So now let's look at the rights of the debarred representatives. Debarred representatives does have the rights. The FSP must therefore inform the debarred person of his or her rights in terms of the Financial Sector Regulation Act, namely the right in terms of Section 229 to request a reason for the decision within 30 days after the person was notified of the decision. Again, the right in terms of Section 230 to apply to the tribunal for a reconsideration of the decision, then the application must be made within 60 days, meaning that if the debarred representatives is aggrieved of the decision, they can approach the tribunal for reconsiderations. The tribunal will have to reconsider this application, and based on the merits, the tribunal will inform the FSCA if the decision is set aside or not. Reporting the debarment to the FSCA. The FSP must inform the FSCA of the debarment within 5 working days of the date of the debarment by submitting Part 1 of the debarment notification form by either hand delivery or electronic mail notification. And given the pandemic that we are living with, the FSCA is encouraging all the FSPs to utilize the electronic mail notification. The FSP must provide the FSCA with the particulars of the debarment within 15 working days of date of debarment by submitting Part 2 of the debarment notification form, again by either hand delivery or electronic mail notification. The form must provide particulars of reason for debarment, including the following: all documentary evidence and information supporting the grounds and reason for debarment, a copy of employment contract or mandate between the FSP and the debarred representatives, a copy of transcript, minutes, and outcome of the debarment hearing, forensic or investigation report, and any other relevant documents. The role of the FSCA upon the receipt of the debarment notification. I need to emphasize this because at times the representatives, they are of the view that the FSCA does approve the representatives. The FSCA does not review, approve, or confirm a debarment of a representative by an FSP. The administrative action is complete once the debarring FSP takes a decision. The FSCA mainly records the fact that a debarment has occurred in the register for the debarred representatives, which is published on the FSCA's website. The FSCA is therefore not required to engage with a debarred person in order to afford such a person an opportunity to make a submission as to why the debarment should not be recorded or published. The FSCA is not required to engage with the debarred person. We are getting queries from the debarred representatives saying they were referred to the FSCA by the FSPs. The FSCA is not required to engage with the debarred person. If the debarred person is aggrieved of the decision, they must approach a tribunal for a reconsideration of the decision. The reappointment of the debarred representatives. The removal of Section 14(1) debarment is unfortunately not automatic, and as such, a debarred representative cannot render financial services unless reappointed as representatives. The FSCA cannot lift a debarment unless instructed to do so by a tribunal or a court of law. Even though the FSCA is not empowered to interfere in reappointments by the FSP of the debarred representatives, the FSCA will always satisfy itself that the process of reappointment was followed correctly. The reappointing FSP must request the FSCA to remove the debarred representative from the database of the debarred representatives. Before making such a request, the reappointing FSP must be satisfied that the representative is a person who is honest and has an integrity. And furthermore, be aware of the details of the representative's transgressions and be satisfied that the representative will not commit an offense again. So the debarred representative can only apply to an FSP for the reappointment as a representative of the FSP, provided that on the date of reappointment, 12 months have lapsed since the debarment date, unless if the debarment was as a result of the applicant not having qualified as contemplated in Section 13(2)(a) of the Act, meaning that if the representative is debarred today, he or she cannot be reappointed the following week or the following month. 12 months must be elapsed since the debarment date. All unconcluded business of the debarred representative must have been properly concluded. All complaints or legal proceeding regarding the debarred representative have been properly and lawfully resolved or concluded. The debarred representatives must have fully complied with any decision, determination, or court orders issued regarding the matter. All fit and proper requirements must be met before a representative can be reappointed. So in closure, I firmly believe that today's webinar was informative and has refreshed your memories when it comes to Section 14(1) debarment and the reappointment of debarred representatives. And I will be taking few questions before I end my presentation.
Thank you very much, Nare. This was really informative. I just want to ask a couple of questions to make sure that I understood your presentation correctly. So I heard you say that due to COVID-19, the FSCA prefers electronic notifications for debarments. Can you please confirm the email address that must be used?
Okay, thank you, Charene. Thank you for the question. So the correct email address to be used is debarment@fsca.co.za. Debarment, one debarment, debarment@fsca.co.za.
Excellent, Nare. Thank you very much. And that's much preferred to hand delivery because this way we know that the debarment documentation will be received.
Correct.
Excellent. Then, can I ask, in CCMA cases, can the CCMA set aside a Section 14(1) debarment?
That's a very interesting question, Sharon. Thank you for the question once again. The short answer to this is no, and I will explain why the answer is no. Remember, the CCMA deals with the labor matters, applying labor laws, not FAIS matters. For example, the rep can win a case at the CCMA, but that does not mean that the rep is fit and proper. So the CCMA cannot set aside a Section 14(1) debarment. Only a tribunal or a court of law can do that.
So if I was a rep and I won my CCMA case, could I then approach the tribunal and ask them to consider the matters before then and set aside my debarment?
Correct. That case will be considered based on its merits by the tribunal. But the CCMA cannot instruct the FSCA to set aside the debarment.
And I think that's very useful because a lot of people don't understand the interactions between the CCMA, the FSCA, and the tribunal.
Correct, because we've seen in the past whereby the representative will say, no, but I've won the case at the CCMA, please lift my debarment. Like I said, the CCMA deals with the labor matters. They're not assessing a fit and proper requirements. So the correct channel is to approach the tribunal for reconsideration, and the tribunal will instruct the FSCA based on the outcome of that reconsideration matter to say, should we uplift a debarment or not the CCMA.
And that's a very useful distinction. Thank you so much for explaining that. So my last question, Nare, is about the FSP's role when the representative is no longer on their license. So if the FSP finds out that a representative that they used to employ really isn't fit and proper anymore, can they still debar that person?
Okay, thank you, Charene, for the question. The short answer to that is yes. The FSP still retains the obligation to debar a person who no longer is a representative of that FSP, provided that the following requirements are adhered to. 1, the reasons for debarment must have occurred or become known to the FSP while the person was still a representative of that FSP. That is the first requirement. The second requirement is that the debarment process must commence no longer than 6 months from the date of the person ceased to be a representative of the FSP. The short answer is yes.
Nare, thank you so much, because I think a lot of people don't understand what happens when the person is no longer their representative and they then find out that there were issues such as fraud or other kinds of dishonesty and they have to take action.
We have seen that in the past.
So thank you very, very much. I think this was a very informative session, and I hope that people who listen to this session will also find it very useful.
I think so.
Absolutely. So from a practical perspective, for those of you who've participated in this webinar, congratulations. It was a very good choice for you to decide to participate in our webinars. We are accrediting all of our webinars with the Financial Planning Institute for CPD purposes. So if you want to obtain CPD points for having attended this webinar, you now have the option of completing the assessment. And on the assessment, you will find questions that pertain to this specific webinar. The answers will be in the discussion and in the slides. And if you struggle with an answer, you are most welcome to repeat your watching of the webinar. And then on successful completion of the assessment, you will be able to print your own CPD certificate. You can save that to your records, and then you have that as a CPD activity for your records. Thank you so much, and we hope to see you at our other webinars as well.